o'clock Pacific. Joined today with only one of my colleagues, Damien Schiff, senior attorney here at Pacific Legal Foundation. It was the last week of oral arguments for the court. We also had a couple of opinions, one that has generated quite a bit of commentary. And we have a new grant that our friends from the Institute for Justice are involved in. But Damien, where I would like to start is with the two opinions that came down this week. And let's get right into it by starting to talk about Louisiana versus Calais. This case dealt with Section 2 of the Voting Rights Act and whether redistricting efforts, so-called cracking and packing, whether those types of efforts violate Section 2. And in particular, what happened here is this case had been argued in front of the court last year in a different posture. There was a Section 2 case brought under the Voting Rights Act in a preliminary injunction fashion that was held to be a violation of Section 2, what Louisiana had done. They had redistricted their state, and plaintiffs brought it and said, no, you can actually create a second majority black district here, and therefore you're not giving those voters the option to vote for the candidate of their choice. That was originally held to be on a preliminary injunction posture likely to succeed. In response, Louisiana went back and created a second majority black district in the state, and then that was challenged by other voters as a violation of equal protection. That decision was originally petitioned by Louisiana last term as, look, we're just following Section 2. The court told us we were in violation of Section 2. If complying with Section 2 isn't a compelling state interest, and we don't know what is, we think that our map that has two that we created in response to the first lawsuit is therefore constitutional. The Supreme Court heard argument in that last term and did not decide it, but instead ordered re-argument this term on the question of whether Section 2 itself, insofar as it requires a state to draw a majority district on the basis of race, violates the Equal Protection Clause. Louisiana sort of switched positions then and said, yes, I guess if you're going to allow us to argue this question, then we agree we should not be forced to comply with Section 2 in a manner that requires us to use race. And if it does require us to use race, then Section 2 is unconstitutional. Now, Damien, this is certainly PLF filed an amicus brief in this case. Full disclosure, this is not your area of expertise, but I know that you've had a chance to at least look over the opinion. What's your understanding of what the court ruled in this case?
Well, and lack of expertise has never stopped me before from pontificating on this podcast. So I won't break new ground here. Well, as I understand it, the court sort of saved Section 2 of the VRA by pretty substantially narrowing it and reading it to only require the use of race in redistricting where the plaintiff has shown that there is, I guess, a substantial, I'm paraphrasing, but that there's substantial evidence leading to a very strong inference that race was a motivating factor for the redrawn map. And the court sort of reinterpreted the so-called Gingell's factors, in particular saying that now, sort of in the modern age of computing and algorithms, that to make this a prima facie showing, if you want to call it that, the plaintiff has to show a map that achieves all of the state's legitimate districting goals while also still producing a majority-minority district. And importantly there, Justice Alito in the majority says a legitimate goal is just pure partisan advantage. And then secondly, notably, the court said on, I think, the second and third Gingell's factors that you also have to show that there's racial bloc voting, meaning that you have that the voting is not more appropriately understood because of partisan preference, as again, the court cited, I think back in like Texas in the 1970s, 1980s, that you had you had substantial white votes going for white candidates regardless of party preference. And so I got the impression that it's going to be almost impossible for the modern day Section 2 plaintiff to make those showings, because the reality is, and Justice Lewis does a good job of this, saying that things have improved substantially, in part because of the Voting Rights Act itself. It kind of reminds me of the same line he had at the opening of the Sackett 2 opinion, where he says, yeah, water quality is better because of the Clean Water Act. That doesn't mean now that we can allow the statute to do whatever we want in today's climate. And I think that was the big takeaway I took from being an outsider in this area of the law, is that the court's just updating things to reality, and that the South is not today the way it used to be, and that, let's be frank, that political parties are ingenious, and they're going to try to use whatever they can to get a partisan advantage. But if the premise is true that the Constitution is essentially, at least the judiciary is essentially hands off when it comes to partisan gerrymandering, then there's no claim here.
Yes, I think that's a very good summary. From someone who knows only a little bit more than you, I think you did a pretty good job of summarizing. I always called it jingles, but you say gingles? Is that right?
I believe I believe it is pronounced with a hard G, but I won't bet the farm on that.
Fair enough. Yeah, so I have to say, when I was first told that they did not strike down Section 2, I was a little bit disappointed. I called up our colleague Chris Keyser, who wrote our amicus brief in this case, and he sort of talked me down from my ledge of what is the court doing here, because I think the court has done so much to eat away at the real problems with Section 2 that it did sort of require states to think in a race-first manner when they were engaged in redistricting efforts. And they did, yeah. And I think there are a couple big things that Alito does with this opinion. You've highlighted a couple of them. The fact that you're going to have to show that a state's political goals can be met with, quote, an alternative map. He's like, all of this is done by computer now, and you'll have to show that the state's political goals, incumbency protection, et cetera, can be met with an alternative map. And I think, frankly, right there, it's not even a question of whether they can prove it in certain circumstances. I almost believe that you probably could still show that certain districts could be differently constituted that may benefit African American voters in some sort of hypothetical sense, but it's not going to produce a different political outcome. And if that's true, it's not even a question of whether this is gutting Section. It's that people won't bring the lawsuits anymore.
Right.
Because it lays bare what we have all known about this, is that Section 2 has been a brazen political tool, and has long since been a focus of discrimination, rooting out discrimination, and rather it was creating districts that would vote Democrat. Now, why I still don't like why I would have gone further is it sort of still countenances, although Alito does take exception to this, but by virtue of the fact that it's not been struck down, the idea that a racial group can have a candidate of choice sort of strikes me the wrong way. Everybody is an individual, and individuals vote according to individual preferences, and the idea that a racial group can have a candidate of choice strikes me as a impossibility almost.
I'm curious, given your experience in this area of the law, what do you think of how revolutionary would the Thomas concurrence be, saying that the statute lists these various things that can't be done in the voting context, and Justice Thomas, joined by Justice Gorsuch, says that, well, maps are not one of those things.
Right.
So we'd even be talking about this.
Isn't a device or a procedure? Well, yeah.
Yeah.
Well, I mean, it would be revolutionary insofar as that would eliminate all of these redistricting lawsuits under Section 2 that come every 10 years. I mean, it's like clockwork. 10 years comes along, and then you're going to have Section 2 litigation. But like I just said, I think the majority opinion essentially does the same thing. I guess that's probably why Alito joins it in full, because if you can't disentangle race and politics, or if you have to achieve the same sort of political goal, I don't see the dollars going into these lawsuits that we've seen going into these lawsuits to elect individuals from a different party. It's just not how it works. And we'll see. I mean, maybe there will still be successful Section 2 litigation. And frankly, if a plaintiff can meet this, I suppose on some level I agree with Justice Alito that if you can disentangle race and politics, if you can show that they chose this map over another map in order to disenfranchise a racial group, then maybe that probably is a compelling interest. I should add, the other thing that Justice Alito said, but didn't go as far as I would have liked, is he said, this idea of like historic discrimination and the totality of the circumstances add-on in Gingles. He would say, like, we're going to completely de-emphasize historical discrimination. What the Voting Rights Act is concerned with is eliminating contemporary discrimination, but he didn't completely say that historical facts are irrelevant, which I suppose is probably true, but I just feel like there's little doors that have been left open here and there in this opinion. Now, again, I think that even though those doors are left open, I think the likelihood that Section 2 litigation, which is very expensive, will be brought in order to ensure a different Republican or a different Democrat, not an additional one, is elected, is highly, highly unlikely.
Do you think that any of those small doors that were left open were to obtain the signing on of a particular justice, or do you think that was just simply prudent decision making that, well, we don't have to decide it, so we won't?
Yeah, I mean, I don't know. I think it strikes me as something the chief would have liked, in that he doesn't want to have to strike down a part of landmark civil rights legislation. Just like if you remember the Section 5 litigation, Shelby County versus Holder from 2013, we had argued in that case that they should strike down Section 5. And that's how it's sort of like pitched. Like if you hear in the media, like they struck down Section 5 and now they're striking down Section 2. But they never did strike down Section 5. All they did was they struck down the coverage formula, which is Section like 4B, I think, of the Voting Rights Act. So it's just like you have to do a coverage formula that maps to contemporary realities. And of course, they can't do that because voting in the South today mirrors that in the North, and there's really no reason why a certain jurisdiction would be covered today that's the Section 5 stuff. So on your question, yeah, I can see the chief saying, hey, we don't need to strike down Section 2 here. We don't need to strike down the candidate of choice language. We just need to make clear that if a state is only in violation of Section 2 for redistricting purposes if and when they can disentangle race from politics, they can show that there are contemporary racial discrimination that's going on that they are trying to remedy, and they can show that these goals can be met with an alternative map. Then we can see a viable path for Section 2. So it just seems like it has the chief's handprint on it, even if I don't know if it was absolutely necessary for him to come on board.
Now, given the Chief Justice's interest in race issues, are you surprised that he didn't write the opinion himself?
Yes, but we didn't know. I mean, the prognosticators can see like which opinions have been assigned during which months, and everybody sort of knew Alito was writing this one. So I'm trying to remember which opinion during this month the chief took for himself, but I don't recall offhand. He must have already written for, I think this was a October argument.
I see. I see.
You know. I do want to say a little bit about the Kagan dissent. She starts out her dissent. Now I think I have it up here, or if I don't have it up, I remember the point that I want to make. Her exam. So she starts off by saying, "This is, an awful day for the Voting Rights Act, and let me give you a hypothetical to demonstrate how crazy this is." She says, "Imagine there is this hypothetical state that has a circle in the middle that is majority black, and then it has sort of like 6 districts on the outside that are majority white." She says, under this opinion, in the next redistricting cycle, the Republicans, if they are in charge, they could take a little bit from that compact circle and spread them out to each of the other districts to ensure that no African American or no person within that circle would get to elect. And she said, "See, this is obviously crazy. There's everybody would see that they're just taking away the electoral power of the African Americans in that central district, and this is what the majority count in this is today." What is your sort of initial reaction to that hypothetical?
Well, it does sort of then underscore, I think, the attractiveness of Justice Thomas's concurrence, which is, it just kind of shows that, voting is supposed to be an individual right, and it just seems kind of weird to ask, and this is not directly responsive to your question, but it does highlight to me the mismatch here. Weird to ask that we're depriving a certain racial group of the quote-unquote ability to elect, quote, one of their own. I mean, that it seems very awkward to say. But moreover, I mean, to me, wouldn't that be one of the examples where these fancy algorithms would be able to spit out immediately all these other substitute maps that could achieve the same nonpartisan or the same non-racial goals without eliminating the majority-minority districts, and therefore...
The idea is that because the Republicans, let's just assume the Republicans are the white and Democrats are the black district, the Republicans would want to have 7 districts that are Republican voting. And so they would take the one, and now they have 7 equally sized districts instead of 6 and 1. And so I think it would be near impossible for a computer algorithm to come in and create 7 Republican strongholds while also maintaining that insular minority district. Are you following me?
No, but that's okay. This is
well, here, I think Justice Kagan's point is at point now, there's 6 Republican districts and 1 Democratic district. In the future, the Republicans are going to district out that Democrat district, so it's just 7 Republican districts. And your question to me was, isn't this a perfect example of where the computer algorithm could come in and maintain a black district while also maintaining the political goals? And my answer is, I don't think so. If the political goals are 7 Republican districts.
Well, maybe the answer is that you could have like a causation problem here. I mean, if you only have 100 people of a certain minority in a million person state, then you're not going to get a district for yourself, right? So I mean, isn't that kind of...
Yeah, I mean, maybe I think the answer is simpler than that. It's like, yeah, well, you're not entitled to your outcome. I mean, it seems a little bit stark to say, but like, just because your skin color is X doesn't mean you're entitled to a political win. And that would be true no matter what race you are. And so, you're right, Justice Kagan, that example is perfectly plausible. Just like if you go to Massachusetts, they have gerrymandered out every Republican potential. And gerrymandering for political purposes is as old as time. And just because a larger percentage of the people in this district, your hypothetical district, are black that want to vote Democrat doesn't mean that they're entitled to an outcome.
Yeah.
It's just it doesn't move me in the way I think that she expects it to move people.
Yeah. Well, and I think that's in part, again, it highlighted in the majority opinion that times have changed. And, people sort of realize that this is more of a political issue now than it used to be.
Yeah. Yeah. I mean, I was thinking a little bit, now we're talking quite a bit about this case, but it is an important case. A little bit about, wasn't that long ago where the court held that partisan gerrymandering is not justiciable, right?
Right.
And I do sort of recognize, especially this year, where you have California doing what it has done, Virginia doing what it has done, Texas doing what it has done, that it's going to get worse in the short term, this partisan gerrymandering for whatever ends. So I thought to myself, like, maybe the court was wrong there. Maybe there should have been an opportunity to challenge partisan gerrymandering in some respects. But then I thought, like, what would that mean? That would mean that there would be a nonstop litigation over something was an unconstitutional partisan gerrymander. It would just,
Yeah.
and frankly, the reason I bring that up is that's basically what Section 2 has turned into. It has turned into the tool that partisans can use to try to use the courts to create districts that will vote for their preferred candidate. And it is so untethered to the idea of uncovering or unrooting intentional discrimination that it's lost its way. And I think this decision is a reflection of that.
Yeah. There's something, though, presumably stopping states themselves from saying, we don't want partisan gerrymander. I mean, at least, theoretically, that's what these independent commissions are supposed to at least prevent the extreme excesses of. But I suppose if we call it the Gingles factors, we'd probably call it gerrymandering.
Been saving that one? Yeah, I will say, I think California does have like a California Voting Rights Act that is very much effects-based and racial group-based. But anyway, I digress. I think this is an important case. I don't think it went as far as I would have liked. I think that they should have made clear that voting is an individual right, and you can't. And I would have wished they would have tied specifically enforcement. And there was some City of Bernie talk in here, but enforcement under Section 2 of the 15th Amendment to intentional discrimination. They've still left open some quote-unquote effects, which is, I think, not congruent and proportional to Section 2 of the 15th, to Section 1 of the 15th Amendment. But all in all, I think this is going to put a big stop to the racialized voting lawsuits that have sort of been perpetrated under Section 2's name for the last 20, 30 years.
Yeah.
There was a second opinion this week, and that was in First Women's Choice versus, was it New Jersey or something like that?
Attorney General of New Jersey, yes.
And what was this case about, Mr. Schiff?
Well, as I understand it, the petitioners are a pro-life crisis pregnancy center organization, and they operate in New Jersey. And the then New Jersey Attorney General became concerned that pregnancy centers like this were misleading the public into thinking that they also provided abortion-related services. And so as part of this investigation, the Attorney General served a subpoena on the petitioner, requesting, among other things, the identities and contact information for some of the center's donors. The idea being that, well, if the donors have been misled about what the centers do, then that could be the basis of some sort of state fraud or unfair business practice claim. And this is something that a lot of quote-unquote blue state attorneys general have been doing in other parts of the country too. And so as I understand it, the petitioner challenged the subpoena on First Amendment grounds that there's this established right going back decades to maintain the privacy of nonprofit organizations' donors, that is grounded in the idea of the freedom of association, that freedom of association is an important corollary right to all of the rights also enumerated in the First Amendment, and that this subpoena was threatening that right. The lower courts threw out the case on a procedural ground, or I should say on a jurisdictional ground, that the subpoena didn't create a sufficient controversy to enable a federal lawsuit to challenge it on First Amendment grounds, because it wasn't, quote, self-executing, it hadn't already been enforced, the Attorney General hadn't taken any steps to penalize the pregnancy center for not immediately complying with it. And so that, as I understand it, was the issue presented to the court is, can the petitioner at least get in the door to argue that its First Amendment rights of association have been violated, despite the Attorney General not having yet, quote unquote, enforced the subpoena.
Right. And the Supreme Court, Justice Gorsuch opinion 9-0 with no other opinions, upholds the center's right to sue and right to bring a First Amendment claim, and big win for standing purposes.
It is, and I will say, we've expressed on this show before some circumspection about standing doctrine or other things that keep claims out of court. Here, I wonder how broad this decision will be in other contexts, because it seems like the court really drew upon the fact that the freedom of association can be harmed without the government doing a whole lot. Mm-hmm. That it's not implausible to think that, just by having like a press release, even not even a subpoena, just a press release saying that we're going to be targeting this pregnancy center, you could see how plausibly that would make people less likely to want to associate with it. So it's an even stronger argument here, because it was a legally enforceable subpoena, even though it hadn't yet been actually enforced. So I agree, it's a good decision. It's not controversial, as demonstrated by the 9-0 result. But I do think it's going to be hard to extend it beyond the unique qualities of the First Amendment.
Yeah, I should also add that we did file an amicus brief in this case as well. We have an interest in protecting anonymous donors. There are many anonymous donors to PLF as well, and their right to associate. So we have an institutional interest in it. Yeah, I think there is some unique First Amendment interests that are at play here in the injury context. I will say, what also strikes me is, I think this is related to one of the cases we were discussing last week. The actual command, I think, of the letter is also quoted in the opinion of, "You are commanded hereby to deliver us with under pain of contempt," and there's like, no. I mean, how common is this practice where the government is just like standing over you, saying at the point of a gun, deliver all of this, or you're going to be in contempt, and then the moment you sue them, it's like, we're just joking around. We didn't mean it.
Yeah, right. Well, it's funny because our dear colleague, Mr. Dunford, who's not with us this afternoon, he was the lead on a PLF case about a year ago, and kind of a similar situation where our client was an importer of fireworks, and the pertinent federal agency, Consumer Safety Products Agency, gave this company a notice saying, "You're violating the law. These are dangerous. They have too much pow in them, and you can't sell them. And if you do, you're subject to all of these penalties." And reasonably so, the company wanted to seek judicial review of that, and the lower courts said, "Well, sorry, it's not final, because there could be some further internal decision making by the enforcement agency. The commission itself could decide that it doesn't want to act upon it, and even though it's still hanging out there and it hasn't been rescinded, this notice of violation, you can't sue on it immediately." And we sought review from the Supreme Court unsuccessfully. I think, one of the big differences between that case and this case is the First Amendment, because the arguments that the fireworks company wanted to make were good ones, but they weren't constitutional arguments. They were just saying that the regulations don't forbid these fireworks.
Yeah. Last question that I have is, we had Americans for Prosperity case versus Bonta not that long ago that dealt with donor privacy. Of course, there's the NAACP case versus Alabama from, I think, the 60s.
Right.
On what basis are these state governments going after anonymous donor information? Isn't it, I mean, it shows my ignorance a little bit. We don't litigate here very much, but isn't it like Hornbook law that you can't get donor information like this?
You would think, right? Yeah. I mean, I'm curious on the merits what the defense of New Jersey is going to be. I kind of feel like they're not going to defend. They're just going to say, okay, well,
Yeah.
we're going to rescind our subpoena.
Yeah. Well, and Justice Gorsuch noted, I think, in his opinion, that there was a wide diversity of amicus briefs in support of the petitioners in this case, including from the ACLU and
Right.
and et cetera. So
Right.
those were the two opinions, but we also had our final week of oral arguments. Tip went out for the Supreme Court. It's coming to a close. We're here in May. We only got 2 months left for opinions, but the last three, I guess 4 or 5 oral arguments. We'll go through these a little bit quicker, but let's start with, was it Chattery?
Yes, the Fourth Amendment geofence case.
The Fourth Amendment geofence case. And these, I was amazed, maybe the court itself is getting a little sad that its time is coming to an end, because this argument was like 2 hours long.
Yeah.
There was a couple of really long arguments this term, and this case dealt with a geofence warrant, which, as I understand it from listening to the argument, is when the cops, they knew some sort of area where they thought the perpetrators of a crime were, and they went to Google and they said, give us the location data you have for people that were in this area, and Google gave them a list of people and they narrowed it, and then Google gave them more information on the people they narrowed it to. And the question is whether this is sort of violating the Fourth Amendment, whether it's I guess the first question is it a search? Second question is, if it is a search, is it a reasonable search? And related to that is, because they did get a warrant here, was there sufficient particularity in describing the places to be searched? Because this is pretty, open-ended in terms of what's being searched. And also, are individuals' privacy rights being violated if they don't even know that they're like sort of third-party individuals who were in the area that weren't committing any crimes or weren't even alleged to commit any crimes, their data is being turned over to the police. Are sort of this bucket of ideas, is this a violation of the Fourth Amendment? I think it's a really big issue insofar as, the tools that the police have to search today are a lot different than I think what were contemplated when the Fourth Amendment was adopted, and yet are even sort of like leaps and bounds different than what was contemplated by modern Fourth Amendment jurisprudence. If you go back to the 60s, they weren't thinking that police could geofence an area and get all of this aggregated location data. So it's sort of the intersection of one of our core constitutional rights and modern technology. Thoughts?
Is there a question there, Your Honor? Well, it's one of those things where, so a warrant was obtained, and I think the question is whether each successive search through the search engine or whatever this cloud thing is, whether each closer search required a new warrant, more or less. That they came up with 19 hits, but it was totally anonymized. Even the police had no idea who they are. So they did another closer search, and they eventually came down to 3 people. So Justice Alito had a good point where he said, there are 500 million people who have their data, their location data, and he was arguing, not arguing, but I mean he was taking exception with the Mr. Chatry's counsel about how drawing an analogy to a hotel, and wouldn't we say that if they have probable cause to search one room, wouldn't it be excessive to just get a warrant for the entire hotel and search every room. And then Justice Alito said, well, you know, you can imagine people would be pretty upset having their room searched, but here we have 500 people, they have no idea what even happened. Even the 19 who were subject to the initial search were totally anonymized, they had no idea. And then the Chief Justice noted, as did others too, that this is the type of data that you have to affirmatively authorize to be uploaded. So there are some policy questions on that side. On the other side, you know, there is the concern about grabbing information from sensitive locales. It kept coming up that a number of the people who fell into the hits, at least at the anonymous level, were just sitting in a church that happened to be nearby. But then the government counsel,
the chief had some concerns about that. Like,
yeah, but then the government counsel came back and said, well, you know what, we had actually probable cause that maybe the bank robber was in the parking lot of the church. So, and then it was a strange sort of academic mootness quality to it almost, because apparently Google no longer even offers this, or something's changed so that it couldn't quite happen the same way. So
I think like the data is now stored on your own personal device.
On your own device, I see.
With Google.
Not with Google.
Well, this issue would never. Now the counter to that was, yeah, well, a lot of different groups use the cloud to store location data.
Yeah.
It's not Google.
To me, you know, the government said, we're not saying this applies to email. We're not saying this applies to photos. We're not saying this applies to, you know, your calendar. But the court, I thought, was unsatisfied with that because they couldn't figure out, well, why?
Yeah, right.
Because, you know, kind of the same rationale for being in the cloud and all that would apply to all of it. I also thought it was interesting, though, that the government made, I thought, a good, it's so funny too, I don't know if you know this, Mr. Thompson, but the advocate for the government, the Deputy Solicitor General, was Mr. Fagan. I was listening to him, I thought to myself, he sounds a lot like Justice Breyer. Lo and behold, he clerked for Justice Breyer about 20 years. He had kind of a similar speaking style. Anyway, he made the good point, though, that yes, it is like we're going to a storage facility, yes, but it's like a storage facility with glass walls.
Right.
Okay, yeah, I mean and
that was the big, that was the hypos on both sides. So the hypo from the petitioner is like, if you wanted to go to safe deposit box, you would have to get a warrant for a particular safe deposit box. You couldn't go there and say, we're going to open them all up, because everybody would agree that you're violating the and I think that's a pretty good analogy, because that's what he's saying. That's what they're doing here. They're going to Google. They're saying we want all of the location data from all of these people that were here. That's akin to opening up all the safe deposit boxes. And as you noted, the government's response to that was like, okay, we'll use the safe deposit box analogy, but instead of like it being a steel wall, it's like you have a glass wall in front of these safe deposit boxes. You can look in and sort of see without creating an expectation of privacy problem into individual safe deposit boxes.
The other thing too, like Justice Barrett noted, you know, there's no problem like if the government just has a security camera that's on a public street and observes you in a public place. And then that's where, you know, where even the government kind of conceded, no, we're not saying that you can go into the home without an additional warrant using this this geofence data.
Well, he didn't quite say that. He's like, well, we're not, that would be a different case.
Yeah, that's true. Yeah, which is, you know, I can understand why the Deputy Solicitor General wouldn't want to concede something like that, but nevertheless, that was a pretty significant point. I got I mean, I left the argument thinking, I'm not sure which way the court's going to go. I could see it being 5-4 kind of either way. I mean, I kind of got the sense that Justices Kagan, Sotomayor, Jackson, and probably Gorsuch as well were in favor of Chatry, and that Justices Thomas, Kavanaugh, Alito were in favor of the government, and that Justice Barrett and the Chief Justice could go either way.
Yeah, I agree with that breakdown. I tend to think, and Alito said this at one point, Justice Alito said, I'm trying to figure out why the court took this case, other than 4 justices must have agreed to take it. And
right, yeah.
Then he went into sort of like a litany of reasons why he didn't think the court should take it, and that they're just asking the court to write a treatise on the 4th Amendment, I think he said at one point.
Yeah.
I wouldn't be surprised if they dig this one because of all of those reasons. It doesn't seem like it would make any lick of difference in the Fourth Circuit's opinion. It's not like there are alternate bases on which to
That's
affirm the judgment. And
that's a good point. I forget. Yeah, because he made it. Just Leader, I think, and others made a point about how because of the good faith
good
exception,
faith.
a rule that the outcome's going to be the same.
The guy got a warrant. I
Yeah.
mean, and Google doesn't have the policy. I wouldn't be surprised if it wasn't a dig.
Yeah.
I want to note two things from the oral argument that stuck out to me. The first was just the familiarity. At one point, Justice Sotomayor responding, or not even responding, but just she said, "Are you done, Sam? Sam, are you done?" Just like the familiarity with calling Justice Alito Sam, I thought
I missed that. Yeah.
was quite cute. But my favorite part of the argument was Justice Alito, who's been at the forefront of our tongues on this podcast today, pronounced ENBANC in bank as a good American ought to, and didn't say en banc or whatever other ridiculous pronunciation the legal bar wants people to say. So to all of our listeners out there, follow Justice Alito. It is in bank.
In bank.
And thank you, Justice Alito, for doing that. Second argument, Monsanto. What was this one about, Damien?
This is actually one that is kind of on the periphery of our environmental practice here. It is ultimately a state tort lawsuit, a products liability brought by a collection of plaintiffs, I believe, who developed cancer. The argument is that they developed cancer from using Roundup, which is a very common herbicide sold by the Monsanto company. And the argument that prevailed before a jury in Missouri is that the label that was on the Roundup should have had a warning about the carcinogenic effects of Roundup. The argument from Monsanto, with Paul Clement as petitioner, is that the products liability claim, state claim, is preempted by FIFRA, the Fungicide, Insecticide, and Rodenticide Review Act, or something like that. And specifically, there is an express preemption provision in FIFRA that says that no state can change or put anything in addition to what has been prescribed for the label by the federal EPA. I'm paraphrasing there, but the key there is that it says that not only can state law not propose a contradictory label to be put on the herbicide, but it can't even propose something in addition to what is put on the label or required to be put on the label by EPA. So the argument from Monsanto is that, look, EPA was aware of these arguments about carcinogen effects of Roundup. It decided not to include that on the required label. The label here is indisputably what EPA required, and so therefore Monsanto cannot be held liable for not including what effectively, per Monsanto, would be illegal federally to have put on the label.
Right. Yeah, so I listened to this argument, and at first blush I'm like, well, so what happened is a Missouri state court held Monsanto liable for failure to warn of the potential cancer risks. And Monsanto's defense is we followed everything we were supposed to do from the EPA. And the idea that like 50 states, you're gonna have a different label in 50 different states strikes me as a little bit ridiculous. That said, as I continue to listen to the argument, it seems like, well, you know this better than me, that especially there's some justices that have a lot of concerns with the preemption, express preemption, implied preemption doctrines. And if something isn't sort of like crystal clear, impossibility being another one, that the presumption should be that your tort claim can go forward in state court. And the argument is here is, as I understood it, now you might know more about the statute, but there's something in the statute that would allow for, like, if new information comes to light, then you can I'm going to get it wrong, so I'm not going to say it. But essentially,
You can cancel. You can petition to cancel the registration of the pesticide.
right. So all they're doing is bringing new information to light here, and therefore it's not in contravention of the approved label or the regulation, I should say, or the statute, whatever it was. And therefore, you can, it not being expressly or impossible to do, it should therefore not be preempted.
Yeah, I have some sympathy here for the plaintiffs to the extent that usually in federal environmental law, it does just operate as a floor. The Clean Water Act, the Endangered Species Act, less so in the Clean Air Act, but there are a lot of federal laws where the states are allowed to regulate the same thing the feds are regulating more strictly.
Mm-hmm.
And that's effectively here, what the Missouri jury did in requiring this addition to the label. But I think that's kind of what makes FIFRA distinct in the environmental law context, that it's really almost like a field preemption, meaning quite reasonably so, because it's dealing with marketable products. We just want one national standard to govern everything. And so that's why, among other reasons, why you have in the addition to language added to it. I got the sense that really there was no justice who was wholly on board with the plaintiffs here, but I think the more liberal justices were trying to find ways to leave some room for some other type of misbranding claim.
Right.
Not this one, but maybe maybe to carve out something that could be left. You're right in terms of the jurisprudential issue. Justice Barrett was concerned about relying upon a theory other than the express preemption part of the statute. And whereas Justice Gorsuch thought that, well, it seems like it's more of an impossibility case, meaning that you cannot comply with the federal law and also comply with what the jury in the state action told you to do. And I think there are some justices who are less comfortable with preemption than others, especially those theories of preemption that don't tie to a particular text. But here you have both. And so I think given that you have both presented, I think it's pretty likely that Monsanto will win.
Yeah. You think Monsanto's going to win? You think it'll be unanimous?
Yeah, I wouldn't be surprised. Yeah, I mean, in part because, that's kind of why I was arguing in April. I think, usually either it's an emergency issue or it's kind of an easy case.
Okay.
Yeah.
Okay. Let's move to Cisco. This is Cisco Systems. What is Cisco Systems? Do you know?
It's a software company, at least based upon the argument, because this concerns the Alien Tort Statute and the allegations that Cisco Systems, while in the United States, developed some sort of monitoring software that the Chinese government then used to torture and then extrajudicially kill members of Falun Gong, which is a...
wow, good pronunciation.
Yeah, thank you. Which is a, I guess like a quasi-religious group in China that has been persecuted by the Chinese government. And I think the central issue here was aiding and abetting liability under the Alien Tort Statute, which is, goes back, almost 230 years or whatever to the very beginning of the Republic. It seems to authorize the courts to come up with or recognize sort of an international common law causes of action to allow citizens or non-citizens to seek redress for violations of the law of nations in federal courts.
Right.
And that's what the petitioners here tried to do against Cisco, saying that their production of the software and working with the Chinese government aided and abetted the torture of the plaintiffs. And the argument is, well, very complicated case, but I mean, as I understand it, the argument is, first of all, can we even recognize new international law violations, or is it just based upon what they call the Blackstone Three, these piracy or you trip an ambassador or something like that, that were in existence in 1789, or can we develop new ones? And either way, whether we're just bound to the old or we can develop new ones, how do we figure out whether aiding and abetting liability is available? Because it seems like historically, maybe aiding and abetting was recognized when it came to piracy, but obviously what Cisco was doing was not piracy, and so then the question is, do we even need to address whether aiding and abetting liability is ever available, or can we just simply resolve this case by saying, well, at the very least, you have to be relying upon one of these historically pedigreed theories to even hope to invoke aiding and abetting liability. That's where I kind of got where the court was going.
Yeah, I guess the concern here is, I mean, there's a lot of foreign policy concerns here that if you are, which is going to come up with, I think, in most alien tort statute cases, that if you allow litigation in America about practices that are being perpetrated by the Chinese government, how does that affect sort of our international relations? And there should be, maybe we should construe this limitedly and allow Congress, to the extent it wants to expand liability, the ability to do so. Right.
Yeah, this is one of those cases where I thought the plaintiff's counsel, who I don't think is a SCOTUS practitioner, I think he just mainly does these types of tort cases in lower courts. He did a very nice job, but he didn't get very many questions. And usually you think that, well, that means that the court might be leaning his way, but I think the court's going to rule against his position. So it was an interesting dynamic. I do think Justice Jackson had a good point here that the foreign policy concerns seem to be at their nadir here, where you have the alleged illegal activity having happened in the United States by American companies, and so does China really care whether these American corporations might have to pay a judgment? So that's
I agree. It's funny, we didn't both points you made there I was going to make, and we haven't talked about this beforehand, but I looked him up. Mr. Paul Hoffman, the attorney for the plaintiffs here, the respondent in the case, apparently he has argued a number of Supreme Court cases, like 6 or 7. But my if it's the same Paul Hoffman, but I think it is, because it looks like Royal Dutch Petroleum, Nestle.
Oh, very good. Okay, I didn't know that.
My impression of hearing him was, okay, this guy is just like, he's a little bit too invested in the Alien Tort Statute and these types of cases to sort of see the forest for the trees and see where the questioning's going. But he's an experienced advocate. And I will say, maybe he's just up against a rock and a hard place. Like, he's been litigating these cases and the courts have allowed these various causes of action more than the big three. I also say he's, in some ways he's doing the Lord's work here, right? He's defending against the torture of this minority group in China and trying to hold, whether or not Cisco is responsible for that torture, I don't really know anything about the merits of the claim, but, he's trying to do a good thing here and maybe I don't know if he's being handsomely paid or not, but that's the cynic in me coming through. You can support the cause here to hold somebody responsible that has a role to play in the torture of this minority group. That said, I thought it didn't seem to me like he was making much headway with the points he came in trying to make with the justices, and there was no real response to sort of the parade of horribles that I think the government and was trying to make on the other side.
Well, his problem, of course, is that he likes the jurisprudential status quo, and the court, I think, is not happy with it. They want to tighten things up.
Yeah.
And it's interesting too. There was some discussion about the Erie doctrine, and isn't this an odd statute because it seems to be pre-Erie, so it seems to presuppose that the federal courts can develop a general common law, and seems to almost invite them to do that. And the question is, what do you do when you have that a pre-Erie statute that adopts a pre-Erie ideas? I thought that was interesting. Also, I note, just in terms of practicing, Canon Shamigan was for Cisco. I think perhaps this is why he didn't argue the Rooker-Feldman case from a week or
Right.
so ago, because I suspect cert was granted here, and they said, well, this is the paying client, this is the more important one, so we'll hand off the other one to the former Solicitor General to.
It may be because I think I saw this, that he also wasn't counsel of record on the petition in this case.
Yes.
He was counsel of record in the other one and then
Yes.
got supplanted for Preligar.
Yeah.
And wasn't here and got elevated. Yeah, and last point on sort of the counsel's argument, I think, he did make a good point. Like, the pre-Erie statute, I think, is an important one. He's saying, look, the law of nations, we've litigated cases under the law of nations, pre-Erie, often. And this is just an extension of sort of that law of nations ability. And, although I think the biggest comeback here that is hard to overcome is that if Congress wants to expand the Alien Tort Statute beyond the Blackstone 3, it certainly can.
Yeah. Right.
All right, two more to get through. We have the immigration case, which is Trump versus Mio, or Mullen versus Doe. This dealt with TPS classified persons, which is temporary protected status. So I think the Trump administration revoked the temporary protected status of Syrians and Haitians. And there was an emergency application of the court to hold that illegal. I think there was a stay issued that it violated equal protection, and the government sought review of that stay. And how do you think the argument went in this case?
Well, this was argued by the Solicitor General himself. So obviously a sign that the administration takes it very, very seriously. It's another one of these judicial review questions where you have, as I understand it, before Congress passed this TPS statute, basically the executive was kind of doing this on a very ad hoc and somewhat behind the curtains basis, whether to grant this protected status. And so Congress then passed this statute that on its face seems to require the Secretary of Homeland Security to go through this procedural process to decide whether to designate or not designate an area as being qualifying, whether because of internal unrest or because of natural disaster, what have you, and then to consult with other federal agencies before making that determination. But the statute does say that the final determination of the Secretary about whether these countries should still be considered as such that we cannot return nationals to those countries, that's not subject to judicial review. So the question is, how broad is that express bar on judicial review? The challengers here said, well, we're not challenging the final determination of whether Haiti or Syria are now improved enough that people can go back there. We're challenging the various procedural steps that the Secretary of Homeland Security failed to take before making that determination. And so in that respect, it's very similar to a lot of issues that come up in administrative law generally, where you have agencies that have discretion as to the final result, and the courts can't really inquire about that. But you have mandatory procedures that have to be observed before you can get to that final result, and the courts can review that and can overturn the final result if those procedures hadn't been properly followed. So I think that was the template that the challengers here were going to use. It was interesting that the government here even acknowledged that it was not objecting to judicial review of the challengers' constitutional claims. That the only thing it was objecting to was these procedural claims about whether the Secretary basically did the research she needed to do before making the final decision.
I'll say I'm somewhat sympathetic to the respondents in this, in that, again, we have litigated a lot of these APA claims where the government fails to follow the procedures prescribed by Congress, and they're like, well, no big deal. We didn't, no harm, no foul, essentially. And Sauer in this case said, yeah, I think the Ouija board example was brought up by Justice Jackson at one point. He's like, yeah, we can use a Ouija board. You can't review that. And I find that hard to stomach, frankly. Now, even if you have sort of total discretion as to the result, and I think Justice Kagan said, could you just post something on X and say, like, now these statuses are revoked and there's nothing we can do about it? And it doesn't seem like, I mean, I don't think there's really a whole lot of debate that Secretary Noem did not follow the procedures here prescribed by Congress in doing this. So I'm sympathetic to that. I think even though I sort of grant you a healthy dose of, well, if they can do this anyway, no matter if they follow the procedures, what is the problem? There's some of that is nevertheless coming through in my thinking. So I don't know, you who have a lot more expertise in this area, what are your thoughts on that sort of procedural argument?
Well, I think one big difference is it's one thing to say the final decision is so discretionary that we can't inquire into it, but we can certainly review the necessary steps to get to that final point. That's what we have run into a lot here at PLF, and it's common administrative law. Here it's a little stronger, because here we actually have the statute saying you cannot review this determination. And so then it becomes a little harder to disaggregate the steps that lead into that final determination without basically undoing Congress's express prohibition against reviewing that final determination. Right. And so, plus you also have the fact, this came up in Justice Thomas's questions, is that, this is an area where already the executive has a lot of discretion because it's immigration, and the status quo basically had the president being able to do anything, or the secretary being able to do anything. So it's a little more complicated, but yeah, I share your sympathy, especially as the government's already conceding that the constitutional claims can be heard. That now we're just talking about APA-like claims. But, Justice Kagan had some very, very sharp questions for the challengers here when it comes to things like, are you separating out like factual versus legal challenges? How far back before the decision can you go and say that you're no longer challenging the determination, but rather the steps that lead up to it? So I suspect that the government is going to win here, although I think it's going to be largely tied to this express judicial review prohibition. And that also kind of came up too in the argument, is that when you hear about these awful examples of what if they just simply put names in a hat, or these are the ways you would have you. And then I thought the Solicitor General kind of had a good response, which is, well, that's the cost of no judicial review provisions, and Congress presumably knew that was a cost, and I think that's a good answer.
Yeah. The story that came out of this argument was on the constitutional questions, and I think Justices Sotomayor and Jackson, on the one hand, were trying to pull some quotes from Trump about we don't want the Haitian immigrants to sully the blood of Americans and stuff like that, why do we have to accept these immigrants from Haiti and Syria, and we can't get any from Norway and Denmark or something like that? And that these allegations, these statements, sort of make out a good Arlington Heights case. And I think Justice Sotomayor said this is enough for Arlington Heights to. And as someone who has litigated an Arlington Heights case and is litigating 3, if that is enough to prove your Arlington Heights case, well, sorry New York, sorry Boston, sorry Montgomery County, and sorry Fairfax County, Virginia, you are going to lose if one statement can be enough, because we have oodles of these similar statements, and these Arlington Heights cases are sometimes hard. They're very, very hard to prove.
Yeah.
But the big story is what Alito's response to this line of constitutional questions was when he started asking the plaintiff's counsel, the respondent's counsel, I think it was, do you consider Syrians white or something like that? And then what about Turks, and what about Greeks, and then Southern Italians, which garnered a chuckle because I guess Alito is Southern Italian or something like that. And the counsel for the petitioner was like trying to say like all these people are not white. And I just find it very uncouth, or just very, it just sort of this idea that we're going to categorize people from different countries according to these broad racial stereotypes, I just find so icky to begin with. And Justice Alito, he started his questioning by saying he doesn't like to do this to begin with, but he wanted to show the hypocrisy in their statement that they're trying to say that this is a racial category when in fact the US government itself categorizes Syrians as white.
Right. Yeah.
So, it's too bad that it came to that. I mean, I don't, but, I don't know. I think, well, I guess we'll see what the proof comes out, but I doubt that, a few stray statements by President Trump when it was the secretary who purportedly had the decision-making authority is going to suffice to make out their Arlington Heights claim, but we'll see.
Well, and I think you're absolutely right. I think in part because of some questions that Justice Kavanaugh asked, where he said, look, the Assad regime was there for 50 years. It was an awful regime, and it's gone. I mean, isn't that like a pretty significant change? For example, that might justify a different approach. And I think, the Solicitor General there had a good point where he said, look, if we keep, say, Syria, for example, as a qualifying area, we're kind of undercutting our message to other countries to say that, hey, now this new regime, it's worth a shot, and we think that they're gradually doing things to improve the way things are governed. Or similarly, with Haiti, the argument is that, well, the best and brightest of Haiti have left because because the government there was in disarray and there was a lot of crime and all that, and so we want to encourage people to go back to Haiti and then to improve the country. And
right.
If we keep it as a TPS qualifying area, then that's not going to happen. Now you can say that's pretext. You could say that that's but the fact that those came up from some of the justices, I think, show how they would deal with some of those incendiary remarks that were quoted from the president at various times.
Yeah. Last argument of the term, of the day, of our Supreme Court show. Make it quick, Damien, because I didn't read anything about this.
Boy, this was a real sleeper. I mean, I couldn't even, I only got through about it. But basically,
Hikma Pharmaceuticals versus Amarin Pharma, Inc.
It's a generic pharmaceutical company that was sued by a brand name pharmaceutical company. And the problem is that the generic company, who was the petitioner here, marketed a drug for permissible purposes, but didn't, as I understand it, didn't include in the marketing or the label an express disclaimer about how the drug could also be used for beneficial cardiovascular purposes. And the respondent here is a maker of basically the same drug brand name for that cardiovascular purpose. So they're upset that they're getting competition for their brand name drug, and they sued the generic company on the basis of inducement to infringe the patent. Oh, has Mr. Thompson left? Oh, I think he might have just left, but I hope he hops back on shortly. But in any event, to finish that case, the petitioners lost in the Federal Circuit concluding that you have to basically actively disclaim the off-label uses to avoid liability. That's somewhat inconsistent, as I understand it, with the general rule in intellectual property that inducement liability requires some sort of active step. I suspect that this will be an I-No in favor of the pharmaceutical company. And, I think Mr. Thompson will be back momentarily. I sure hope so, because I don't know if I can carry on this show. I hear him. Oh boy, yeah. Well, that was some. But in your 30-second departure, I think I was able to summarize that case.
All right. Well, thank you, Damien. So the generics are fighting the name brand. because of, as I got it, the name brand can objects to the generic saying that they can solve the problem that the name brand does.
Even worse than that. So the name brand is saying that because the generic didn't affirmatively disclaim that they're now inducing others to infringe the patent. So the generic didn't say, hey, you can also use this for your heart health. They just didn't affirmatively disclaim that.
Okay. Well, that brings our oral arguments to the close. Quite the slate of oral arguments this year. Maybe we'll do some reflecting on it in the coming weeks as we read up and continue to bring the PLF Supreme Court show to our listeners and the opinions that are coming. Got some big ones, especially in the administrative law space. But before we sign off for today, our friends at the Institute for Justice had a new cert grant, although they were respondents in this case. And what case am I talking about, Mr. Schiff?
Yes, NLRB versus Sun Valley. This is a case where Sun Valley is an agricultural company, I believe, in New Jersey. They were fined for federal labor law violations. And the lower court held that the administrative proceeding in which they were fined violated the separation of powers. I think it was just under the idea that this is the type of case that has to be litigated in an Article III federal court. And the Supreme Court granted review. I think the argument here from the government is going to be that unlike more recent cases from the Supreme Court that have cast doubt on the ability of administrative agencies to adjudicate these types of cases, I think the government's going to say, well, this is a little different, in part because this is really ultimately an immigration dispute, but also because this is not like any sort of common law lawsuit. You know, the listeners, I'm sure, are familiar with the Jarkissi case from last term concerning fraud. Well, fraud's a typical common law action. This is just, you violated some arcane set of labor law rules from the federal government. That's a lot more like quote-unquote public rights that the court has held can be adjudicated by agencies, at least largely. We, of course, at PLF very much resist that idea, as IJ does as well, and would applaud an opportunity for the court to narrow this quote-unquote public rights exception. So that will be something at issue, I'm sure, in this case.
Yeah, well, we're certainly hopeful that the respondents prevail with the great lower court opinion that they achieved.
Yes.
Well, Mr. Schiff, I would be remiss if I didn't have any Supreme Court trivia for you, even though our colleague Oliver isn't here. I know his mother, who I'm sure is listening in, it's her favorite part of the show.
Yes.
So next week is going to be an historic week at the court in that Justice Clarence Thomas will move into second all-time in longest tenured justice. And a quick question, this isn't my trivia question, but quickly, which two justices will he be passing to move from fourth into second?
Douglas? Justice Douglas? William Douglas?
Douglas is first. So he won't
Harlan.
Douglas.
Justice Harlan first? No. Fields. Justice Field.
Justice Field, he will is number 2, so he's second at 34 years, 195 days. And I'll tell you that in third place currently is a contemporary of Justice Clarence Thomas.
Brennan?
John Paul Stevens.
John Paul Stevens, yes. Okay, very good.
John Paul Stevens only missed out on being second by 3 days.
Wow.
Yeah. So, let me ask you a few questions related to tenure on the Supreme Court.
Okay.
What is the shortest tenured justice? Now, you're going to tell me the justice's name or tell me the length of tenure, or both?
Was it Oliver Rutledge?
Rutledge is third to last, and he was a chief. He's the shortest chief.
Okay.
At 1 year, 156 days.
That's the closest I can do.
Well, this one is a 20th century justice, James Burns.
Not familiar with him.
from July 8th, 1941 to October 3rd, 1942. 1 year, 87 days.
Okay.
So let me ask you this. So we said John Paul Stevens, who was certainly a justice while we've both been litigating.
Yeah.
Who is longer, Rehnquist or Scalia?
Scalia was 87 to 2016, so that is what, 29 years? And then
86 to
Rehnquist,
2016.
well, sorry, 86 to 20, yeah, 30 years more, yeah, okay. And then Rehnquist was, I think, 1917 to
72.
72, okay, so that's 34 years.
Yep, so Rehnquist, you're right. You figured that one out.
Okay.
How about Breyer?
Breyer, he joined in 1993?
94.
94, okay, and retired in 2021.
22.
22, okay. So that's what, 28
27 years. Pretty good. Is that more or less than Ruth Bader Ginsburg?
That's more, right?
That is
By a
more
year?
but only by a couple of days, only by about 200 days.
200 days, okay, yeah.
She's 27, yeah. And where do you think Amy, there have been 116, is Amy Coney Barrett top 100 or less than 100, or 100 or greater?
In what's the metric here?
Length of service on the court.
So she's been on since 2020. So
Yes.
that's not quite 6 years, right? Not quite
Right.
6 years, yeah. So she's in the top 100.
She's exactly 100.
Oh, there you go, okay.
All right, last question. I asked our old friend ChatGPT, if I can pull it up here. What are Justice Clarence Thomas's most famous majority opinions? And it gave me 3. And what do you think they are?
Most famous majority opinions. What was the one that oh, it wasn't a majority though, that he said that you had to pay for or something like that?
Yeah, that was the dissent in Raich. That's my favorite.
Yeah, the dissent, right, yeah. Majority opinions. Wow. You know, it's funny, actually, now that you mention it, I mean, I can't think of any, you know, I can't, well, first I start with PLF. I don't think he has written a majority opinion in any PLF case.
Is that right?
I mean, can you think of one?
No.
Yeah, that's very interesting. Okay, so not that I'm so parochial that I only think about our PLF cases, but did he write the majority in? No, it was the Chief Justice in Lopez and Morrison, right?
Yes.
Okay, I give up. I can't name any of them.
Well, now that I've been thinking about it, I wanted to just double check something. The case that ChatGPT gives is McDonald versus Chicago.
Ah, okay, right.
But that made me think, did he write Bruin?
No, that was Scalia.
No,
Sure.
Bruin. Scalia was long gone by Bruin. Bruin was just a couple of years ago.
Oh, I'm thinking of Heller. Sorry.
Yeah.
You're right. Yeah, you're right.
Thomas did write Bruin, so I would say Bruin is probably his
Bruin.
most.
Yeah.
Because that
right.
puts the real test into what Section 2 or the Second Amendment is.
Yeah, that's right.
The other opinions that it gives is Virginia versus Black. Do you know what that is?
No, I don't know that one.
That was a First Amendment cross-burning true threats case.
Oh, that's interesting. Okay.
And one case right down the road, Elk Grove Unified School District versus Newdow. Yeah.
That was a mootness case, if I recall.
Standing, yeah, mootness, yeah.
But how interesting, yeah, it's funny that I mean, he obviously writes a lot of majority opinions, but they tend not to be, I guess, in the really famous cases.
Yeah, yeah. A lot of very famous dissents and concurrences, though. His
Other
dissent is great. His Kelo dissent is great. His Raich dissent is great.
his Saka concurrence is great.
All right. Well, Mr. Schiff, this is quite the long episode. We didn't have Oliver
Marathon.
marking us down. But it's been a very eventful week at the court. We'll try to be back this time, same time next week, going through the summer with opinions coming down. Obviously, if there aren't that many opinions in a given week, it'll be a little shorter of an episode, but we thank all of our listeners for joining us at the PLF Supreme Court show. And until next week, this is Joshua Thompson and Damian Schiff signing off.